All right, everyone. Our next panel is going to be talking about the litigation and enforcement hot topics as they relate to RIAs. Unfortunately, even with the change in administrations, it appears that litigation and securities enforcement actions are still coming fast and furiously against RIAs and items. Now, it's interesting. We're going to see, I know that on the commission's docket, there are a number of settlement agreements currently with RIAs. It's going to be interesting to see what happens to them after the shutdown. And I know that there are a number of investigations that we're working on that have kind of been shuttered because of the shutdown. And we'll see how they start up again. But this is sort of like the time we wanted to put this right in the middle to like sort of ease you into it. If you follow everything Mark and Kimberly and Sahir said to you on the first panel, you won't have to worry about Brian, Rich, or Mark again. So let's hope that's the case. But without further ado, I want to introduce my partner, Brian Lanciault, who is going to be the moderator for this session. Brian, why don't you take it away and introduce the panel?
Thank you. Thank you very much, Ernie. I appreciate that. And thank you all for being here today. Litigation enforcement activity in the RIA space, it's always a hot topic. There's always a lot going on. And as Ernie said, even with the change in the administration and the shutdown, there's still a lot of interesting topics that we can explore. We heard about some of them in the earlier panel: fee issues, cybersecurity, preparedness, conflicts of interest, the marketing rule, and things of that nature. And against this backdrop, as technology becomes more and more prevalent, as clients are becoming more sophisticated, it's interesting to see where claims are headed in both the private litigation sector and in the enforcement activity. So, without further ado, you met Marc earlier today on the previous panel, and this is our partner, Rich DeBari. I want to start off by maybe contradicting the first bullet on our very beautiful slides up there about heightened SEC scrutiny. I think there's some interesting statistics that have come out for fiscal year 2025. So that covers the end of the prior administration and the beginning of the new administration, the first 3 quarters of 2025 calendar year. There are only 45 enforcement actions in fiscal year 2025 by the SEC. That's about half of the 98 that came in the year prior, and only 10 of those were initiated after the administration turned over. So if you think that there is some sort of a slowdown or a lack of enforcement, the numbers at least suggest that as of right now, the administration is not overly active, and I'm sure the shutdown isn't helping them with that. But they are still pursuing cases. They have continued to keep the legacy cases from the prior administration, and have pursued new cases mainly focused on fraud, misleading practices, unfair practices, etc. By contrast, I'll give you some numbers from state regulators in a report that came out just a few weeks ago from the North American Securities Administrators. And they reported that in 2024, so there's some overlap, but it's not quite the same time period. But in 2024, state regulators initiated 471 investigations against investment advisors and brought over 100 enforcement actions against investment advisors and investment advisor representatives. So where the SEC is down, state regulators seem to be picking up the ball. But I think, that's a perfect segue to see what our panel thinks about that. So Marc, Rich, what do you guys see as significant drivers of RIA-related litigation and enforcement activity for 2025?
Before we give hi everybody. Before we give some of these drivers, just in defense of our slide here and the veracity of that statement, maybe the SEC scrutiny is still heightened, but everybody is, because of lectures like ours and everybody trying to instill a culture of compliance, even after the scrutiny, maybe there is a lot of compliance and no need to bring on new enforcement action. So maybe the scrutiny is up, but actually you people and the compliance professionals out there are doing their jobs, and the SEC is being satisfied with what they're seeing. Unlike some of the states, which Brian points out, the activity is certainly up. So maybe there's a way to harmonize Brian's statistics with what's written up there.
Just trying to conceptualize this and not to minimize any of the actions, right? So you threw out a lot of numbers, but what's that as a percentage, right? So how many, are they investigating 1% of RIAs? I mean, in the grand scheme of things, this just doesn't sound, I would have expected larger numbers. When you say 400 something across the states, that sounds small.
No, and that's an excellent,
a great point.
That's an excellent point, because as this group knows, maybe more than most, there's been a proliferation of RIAs, even as compared to FINRA registered representative of broker dealers. So as a percentage, we could say that federal enforcement actions and litigations and investigations have decreased year over year, even just as that number, as compared to the, I don't have the statistic on hand, but maybe ChatGPT would tell us if we could believe it, how many more RIAs there are year over year.
Are we allowed to use that?
No, I'm not. How many RIAs there are year over year, even within the same year, it's probably exponentially larger, while the enforcement actions actually have been halved, I think, is what Brian's numbers indicate, as especially as for new enforcement actions from the new administration from the turn of the year as opposed to prior, which have been carryovers. So that's an excellent point. So as a percentage, it's probably quartile, who knows, as compared to the amount of new RAs that have been formed, or even as they've consolidated and gotten bigger over the last couple of years.
And it is worth noting too that even in the state statistics, those are down from the prior year as well. So there's still an overall downward trend.
As we're looking at trends, one reason for this, and we're going to get to this topic a lot more later, I said more on the litigation end. We work, as this team here works on regulatory compliance and response and defense on the front end, on the compliance side as well, but also for private litigation and for enforcement litigation from a state, a regulatory body, or the federal government. So as we've said here, what we've seen is the bull markets generally help decrease the number of enforcement actions and the number of private litigations. I don't know if the 2023 and 2024 market success has, you spoke some of these numbers that we're hearing here on some of the new investigations or not, but usually in downturns and in bear markets is when you get the customers calling, is when you get the regulatory chasing of the customer complaints and issues that are raised organically when people see their balance sheets and get their account statements at year end and they don't like what they see. That usually fosters more investigations than in good times when it's just a fight over who's getting the money and the allocation and the commission splits, which is something you'll hear a lot about here, is divvying up the money and the allocations and being disclosing that and being upfront and transparent with clients in the good times. And it'll be a little different when and if there's a bear market turn, what the SEC will be looking at and what the customer complaints will drive at.
I think we had a question.
I'm sorry, I have to ask a kindergarten question. Could you explain the differences between a deficiency letter, an examination, and enforcement? It's really basic, I apologize, but a couple of people here might be interested.
Sure. So an SEC registered firm should expect within 2 years of its launch an initial exam, right? And that initial exam is basically to level set the operations that you set up. I think it's a bit unfair to issue deficiencies, but even after initial exam, they do indicate things that are not operating as they see them within the normal requirements of an investment advisor. That, because I have led examination staff, I can tell you that though that checklist of what you're looking for is a pretty bare bones review. You don't have too much of a history of your institution. And so almost like a building inspector, they want to come in and say, do you have windows? Do you have plumbing? Does it run? Do you have electricity? Do you have the basic things? And at the same time, they're getting information about your business operation that would inform it on what they may need to think about in terms of risk to the investing public the next time they come. Even though it's very basic, there will be a list of things that they are finding as technical deficiencies, well, actually regulator hates for you to use technical, deficiencies in the normal operations. There'll very often be things like required books and records or processes that you are required to do on an annual basis. Maybe, as we talked about in the last panel, you're doing them, but there's no record for that. Okay, so yeah, you're doing an annual training, but you didn't have a sign-in sheet to prove who was there. It could be something as simple as that. We've seen some more sophisticated requests for information come in, even for initial examinations, that have resulted in deficiencies around computation. That's why we talked so much in the last panel about how you compute your fees and those types of operations. And I would say, I was talking to somebody about this last night, was been completely different. Is that 80% of those questions used to be about operations, to look for risks and holes in the operations that would pose either systemic risk or risk to the investing public. 80% of your questions had something to do with that. They were operational back office questions. Now it's completely flipped, and 80% of them have something to do with the cyber wrapper that you put around your institution to either surveil for or monitor for those same things in that way. And so lots of institutions are picking third-party providers to help them with compliance. Hopefully they're not all using ChatGPT to draft their procedures. We used to talk about inadequate compliance when you would walk into a firm and the compliance manual was still in the shrink wrap, right? And so for those of you who know what shrink wrap even was for your manual, but the analog, but the modern analog to that is what was discussed in the last panel, is, you know, pulling a policy or procedure and it's still got blanks in it. No one's ever looked at it. So it really hasn't been customized to fit your business. A examination staff can refer deficiencies that it finds for further investigation and or regulatory action. And so those can be resolved anywhere from some informal action and a agreement from the institution to do something different going forward, or depending on what they regard to be the severity of the violation, an actual action being brought against the institution for the violations that they find. And those could be formal, resulting in something that would have to be reported on the CRD or IARD of the individual or the company. That becomes a mark, or something informal that wouldn't necessarily have to be reported. In any instance, it's going to involve some remediation action that you are obligated to take, usually with some period of time. 9 chances out of 10, those deficiencies that we talk about, if you haven't had that scenario come up, simply sit in the books and record of files, and they sit with the regulator until the regulator comes back. And the first thing they want to know is, what did you do about these 9 things? It becomes the easiest layup for the regulator to find deficiencies if you haven't addressed those. The trick will come up, and we'll talk about it here, is that the regulators they'll talk to each other, right? And so you might go, whew, that's great, we're done with that. And then 3 weeks later, FINRA comes, and they may find some deficiencies, and they might find that 70% of the failures to send a notice out to the clients were all in New York. Well, then now the New York Attorney General comes, and with an asterisk, they want to ask those questions. So I always say that an examination process and findings really become a roadmap for responding to the next person that comes along.
Thanks. That's a great segue, Mark, into sort of.
If I could just answer their question
Go ahead.
specifically, since I happen to have the information. So the New York Attorney General's office has examination authority, but it does not have examination staff. And so that means the SEC does that, right? The SEC has its actual examiners. Now there is an examination staff, but it really kind of just started. When I was the administrator, that meant that there were 79 examiners for New York only. Their budget from then to now went up from 79 people to around 86 people. This happens, it's not uncommon to this administration, when the budget has been cut and people have retired out and have graduated out. And so that number now is below the 2013 number. But investment advisors have gone up about 30% over that period, right? And so what does that tell you about the ability? Now, they will tell you that there is technology that they are using to make things much more efficient, hopefully not hallucinating violations, right, of individuals that involve. But that's a very important question, not just the empirical number, but what does it mean to the overall numbers? And then what percentage of those then result in enforcement actions, which are uniformly down as they've described.
Great. So jumping off that, I think, an area we should explore maybe right off the bat is, whether and how the state regulators, the different types of regulators, are they complementing, working together with the SEC? Are they picking up in the spaces where the SEC maybe has not shown as much interest in the last year? And what does that look like? What are the areas of focus that the state regulators and the SEC are looking at?
So state regulatory has a pretty predictable habit. In the retreat of federal regulatory oversight, states will usually become more active or more aggressive in the areas where they feel like there's a risk to the marketplace. Now, they don't have all of the surveillance features to do capital markets regulatory, but there's lots of other things where they are operating together. If you're operating in or around the New York regulatory environment, know that the law in New York, the Martin Act, is actually older than the 33 and the 34 Act. And so the jurisdiction of the Attorney General's office in New York is really coextensive with the SEC. And so almost everything that's referred to one is referred to the other. And so that is one of the reasons, as much as they have been criticized, and I've worked there twice, that they are very active in things that seem like national market activity. And so you will see actors, we see actors with an outsized influence and activity in times when there are some regulatory federal retreat by SEC, Justice, et cetera, IRS some as well. So I'd say New York, Massachusetts, Illinois, Alabama, for some historical reasons we could talk about offline, California. Some of the same institutions that you think about as having particularly strong or robust consumer laws will factor prominently in this space. You might also see in times that there is less regulatory involvement. You'll also see working groups of other states. There's a North American Securities Administrators Association, to which every state and Canada and Mexico are parties. And so sometimes they will form investigative groups or working groups to look at particular market activity where they don't necessarily have the resources to do it on their own. An office like New York or Massachusetts, California have enough people that anything that's happening in that jurisdiction that is important to the investing public or sometimes to the person upstairs, there are resources for you to do that investigation and still do the other things that meet your mandate. And they also have a disproportionate amount of investment activity in those states. For things that are retirement leaning, and this may be a unique flip scenario, you will very often have a disproportionate number of the customers or clients in Florida because of retirees, right? And so even though they have not necessarily been the most aggressive, they very often become involved just by the sheer number of investors who are involved in whatever the product or service is. And so NASA did have a meeting in the fall when they announced some of their regulatory priorities. And so some of them are the same. I say they're hyphenated issues or that they want to focus on. They found that many market participant services being offered to the investing public now have some hyphen that has AI at the end, has a suffix for crypto at the end to induce people to invest in kind of the rational exuberance. So any of those products, anything that is market linked, that we consider really sophisticated products in a innocuous wrapper, they have participated in an outsized way in those. There's a whole crypto initiative, not to study it like the SEC has done, but to think about enforcement actions. And then there have been unique things that they've announced in this year, including getting retail investors access to things that used to be restricted to the province of sophisticated investors, including private funds, private investments, certain types of REITs, and so that's ongoing. At the same time, actually, that the SEC, with the commissioner, is talking about granting more access to retail investors, and so they're focused on that.
Yeah, I was going to suggest or offer that there's a political bent, a macro political tilt to all this. You see, as the SEC retreats for political or whatever motivation or direction they get from the executive branch, you see the states step in, right? But it's not necessarily on ideological lines, because Marc mentioned Florida might have a certain political bent to it these days, but they are active and out there because of the elderly population there and investor population base there. Also, Texas is more active than one might think, despite being a conservative state and laissez-faire, let the market work kind of political background. They also are increasingly active in getting into the state regulatory space when there has been a sort of a federal retreat that Brian identified and that we've all spoken about, whether it's shutdown related or just instructions from on high on how to approach the market.
It seems like what you're kind of touching on too is maybe a little bit of consumer focus, right? Who are the constituents in those states? Who are the investors that are being protected, right? That's the mandate of most of these state regulators, is investor protection. So, who are they looking out for? And that leads me to another question, which is, have we sort of gone the way? Is there going to be no more focus on, Marc, you said sort of technical violations? I know that's sort of a dirty word, or are those going to be picked up somewhere? Or is it just the substantive, the fraud, the sort of the elder abuse type cases that are going to get the most focus?
Well, it kind of really remains to be seen. It would track the last 20 years easily if federal regulators said that they were going to focus on the Main Street investor. Those tend to be individual frauds, your crypto, or your IPO offering type things. They are affecting smaller numbers of people and are less focused on large institutional providers. But sometimes there are things that persist. So, for example, the SEC has announced an investigation into what I would call conflicts in research. Now, that goes back to when I was involved in a research analyst case. I was working under Elliott Spitzer. That was a long time ago, right? So everything old is new again, right? And there are questions about whether or not the institution that is issuing research is exerting any type of undue influence on the research department because it wants investment banking, revenue or business. So there are exceptions to that. Now, I think that investigation started prior to this administration coming in. It's just something that they didn't kill. So very difficult to protect. But I think that you're right. Largely, you have states stepping in to those areas that the federal regulator, certainly the SEC, might be retreating from. And some of those large investigations that caused the New York Attorney General's office to be called the Sheriff of Wall Street happened during the periods when the SEC had retreated from those larger national investigations too. I guess you'd see that would continue, and there are certain states, like Rich mentioned, that have an appetite for taking on some of those larger reviews or investigations of investment advisor activity, even where the SEC may not be participating.
And so, I mean, we've sort of said the SEC has retreated a dozen times here. I don't think that's probably completely fair. And obviously, the prior panel talked a lot about compliance and satisfying examination considerations. So, the focuses that we heard about there, fees, cybersecurity, conflicts of interest, are those examination issues translating into enforcement activity by the SEC now? Do we expect that, several months from now? And what is that going to look like?
So I think you've already alluded to the marketing rule, and we talked about it on the last panel. That was the number one topic for the last 3 years. And then this year, it completely disappeared. there are two national organizations that do surveys of investment advisors around the country, and they are providing what their top 3 issues are, either by the amount of time that the chief compliance officer has to spend on them, or the allocation of dollars that are attended to where their spend is. And so I would say one of the biggest changes is that the focus on complying with the marketing rule seems to have died down. There don't really appear to be many enforcement issues, except for fees. For some reason, right? Fees persist. So I would not go back and tell your staffs that we can, put this at the bottom of the pile, because disclosure of fees, fee calculations is certainly of interest to this administration. ESG was a top topic in the past couple of years. That has virtually disappeared, except for the mandate for administrative agencies to look for areas in which there are violations of the executive order against DNI for continuous investing and anything that may represent a fair access law. So that means I have to talk to my clients about whether or not they are invested in any mission-driven funds or participating in that. Now, mostly this has invited some type of splash, and institutions may decide or not decide to back away from those for business considerations. But the one time that it has been challenged in court, actually, the state actor lost an anti-ESG suit. Ironically, the court did it based on a First Amendment Citizens United defense, which is they obviously had a right to invest in what they want to, because a corporation can speak as an individual. So as much as that was used in some prior administrations to attack those interests, I've seen basically any ESG, anti-ESG consideration that has gone out the window. But we have seen PE, private equity interest, and private equity fund formation still be of interest to both federal and state regulators. I think that's part because the commissioner has announced increasing access for the retail public to those suites of investing services, and so they're going to need to come with some parameters. As recently as this week, in an interview on Fox, Commissioner Atkins talked about the need for that. So I think we're going to see some rulemaking that's going to lay the ground for kind of easing some of those rules and widening the potential market base for private equity investment.
It seems like that was, I think, on the rulemaking agenda that we saw from Commissioner Atkins, Chairman Atkins, earlier in the summer. And it seems like that's maybe, to use another maybe dirty phrase, peeling back from the enforcement by regulation, and maybe we're going to stand up some rules around that first and see how compliance develops, what the examinations reveal, and then whether or not enforcement action is warranted to address those issues. I want to pivot just slightly. Oh, we have a question over here. Sorry.
I had a question about this. So I sit on 2 fund boards. One's a mutual fund, the other one's an mutual fund. So clearly they want to get more retail investors into these investment opportunities. We all know this industry. There will be some advisors that are going to issue inappropriate products, putting in some rather esoteric instruments. Now we want to start putting these in retirement accounts. Now we want to make this a part of the default option in 401ks too. So any particular, and by definition, these alternatives are much harder to evaluate in terms of prices. They tend to be higher fees as well. So this is kind of rife for all kinds of issues and lawsuits going forward. My question to you is, fundamentally, as a board member, what are some of the things I should be really looking out for to protect these investors?
I think it's a great question. I'll let the experts take the first crack at that one.
Yeah, I have a couple of thoughts on things to look out for, type of investments or pitfalls. If it's in a retirement account, you could kind of go either way, but one particularly thorny issue is illiquid investments, such as a private equity or one with a lockup date or a lockup period for certain investments, or like a business development company where it's near impossible to evaluate what it will be. For investors of advanced age, that may not make sense because you don't know their time horizon. You know, they may say, "Oh, I won't need the money for 10 years," but then it may not be around for 10 years. And this sort of, even if they have all the forms in place where they'll check the right boxes and informed consent that I don't need this money and it's illiquid, just inherently the proposition of a person of advanced age tying up their money for some unknown amount of time really could just beget a lot of questions on whether that's the right investment for them or whether there were more suitable alternatives for that specific type of investor. So illiquid products with investors of advanced age may not be a fit, full stop. And so I don't know if specific rules or carve-outs or overrides or informed consents will do it, but that is something specifically that the regulators are looking at, because just maybe just on its face, it cannot be a suitable investment or an exercise of fiduciary duty for these.
Disclose it away in the Form ADP.
Yeah, you can disclose it away. You can get informed written consent. Then if they say I didn't understand it, you're back at square one. And for these investors of advanced age, the burden's on the investment advisor to demonstrate knowing, understanding, compliance, and exercise of the fiduciary duty. So note taking, notes to file, not just a signature, but a specific note evidencing the conversation and evidence showing their informed consent will help. If it's not viewed as a regulator, it's just a null set, not allowed.
Should he increase his insurance, his malpractice insurance?
Oh, yeah, we've done that already.
Or not offer, or not offer the product to this type of investor just as a rule. It's also a possible outcome.
I mean, look, they're issuing now interval funds with like minimums of $2,000 where you don't have to be a QIP. That starts the ball rolling, right?
Yeah.
Getting into retail investors' hands who don't know what they're getting in. You can disclose all you want, but I mean, like part of a 401k process, right? The administrator has to be able to educate whoever that employee is in that particular company over and over again about the specific risks involved with these things.
And so some of these risks may be mitigated because it is a retirement account, whether you care for the liquidity or not. You can't, shouldn't get it into the normal course. So maybe that's a helpful fact for a younger investor. But again, as I go back to the advanced age investor with some of these products, it may be a misfit just altogether, unless and until you can explain how you exercised your fiduciary duty and that investor knew what they were getting into if they chose that way.
Have you seen any precedent for a modern portfolio theory argument? So I'm just going to take crypto, perceived as a very risky asset. The beta is 0.5. So potentially in a down market, having some exposure, and perhaps it's also the private investment also perceived as riskier. Having some exposure in these asset classes could, in the portfolio in its entirety, have better, in this case it would be alpha. So there's different definitions of risk, and there's one in the context of portfolio theory rather than just like a Sharpe ratio, which is a risk-adjusted return. So I don't, I just, because I do care a lot about sort of older generations and not understanding, but there is that sort of thesis around the entire portfolio. Yeah,
well, you're already deploying your thought and exercise of your fiduciary. No, but you're doing the right analysis. So long as this is all laid out and spelled out, and or the advisors themselves are educating the end customer, this makes sense. Some would say it's a breach of fiduciary duty not to have 1% in crypto because of the unlimited upside or extreme upside, right? So this is the analysis to undertake, and you're doing it well. So have that in the literature, have that be second nature for the sales force or for the advisors going out there to educate the end customer, and have that all disclosed. There can and will be second guessing if something blows up, but the specific crypto itself, you of course need to do, or whatever digital asset, puts the diligence on the front end, assuming you did the diligence on the custody, and then it's less risky or just enough risk as a digital asset that you're comfortable with to get your clients in. If you do that diligence up front, you do this kind of holistic analysis of what it means as a percentage of a portfolio, and for the specific customer that it's going to, then you paper it, then you've got as good a chance as any to withstand the scrutiny that we're talking about.
I have clients who like crypto and were banging on the door to buy crypto ETFs. And I finally said, fine, but you have to direct me to do it. So they've sent me emails saying, I want you to buy, IBIT or ETHA or whatever. And that's kind of how I deal with covering myself. Because I personally think it's a scam. That's just my opinion as an investor. There's not much of a use case for it other than speculation or money laundering. In the history of private money has never persisted throughout the eons. You can go back to Babylonian times. They always blow up. It might not happen in my lifetime, but I'll make a bet that there will be an event.
Could I just
I try to cover myself by getting specific directions. But other people might like crypto and it's not a solution for them, but I would suggest that's a good one.
Wonderful advice from both of you and from what Rich is saying too. But just on this topic of crypto, if I could offer to all of you, we did a series of coffee chats where we did 2 sessions on digital assets, cryptocurrency, and the blockchain technology. If you go to the Thompson Hine website, you can actually see them at any time. So I would offer those to everybody. And if you can't find them, we'll get them to you. I don't share my buddy's opinion about crypto per se, okay, right? We do a lot of work in the crypto space at Thompson Hine, and we certainly don't recommend any particular cryptocurrency because we have a variety of clients who are involved in a variety of digital assets. But I think what you're saying, the overall thing of being skeptical, it's with any investment. You should be skeptical of Berkshire Hathaway. You should be skeptical of Amazon, all of those investments. And I think that's a good thing to document into, like the last panel was saying about keeping records.
Could you
Just a little worried about crypto.
Could you give some practical advice as to whether his strategy is saying direct me to do it is sufficient so that he is not personally liable?
I think Marc and I both have an opinion on this. I'll just offer very quickly, and that is, I think asking your client to direct you, to say you're uncomfortable recommending it, is always a good strategy. No regulator is going to say, you shouldn't have done it. But Marc, do you have a different opinion? Or
I was just going to add, I agree with that. I was going to add, you may want to consult your investment advisory agreement to see whether or not how discretion is defined, because there are some kind of compliance structures that are designed as you having 100% unfettered discretion. Some go on to say that your fiduciary duty includes the right to refuse to invest in something that you have determined is not in the best of your clients. And so, not that you couldn't then get a release from them, but I'd want to know what your advisory agreement says. For some, you are acting at their discretion, whether or not you think it's in the best interest of the client or not, and then you know what that is. For those that have automated procedures, you want to know what the triggers are for those investments or not. Say that you are running a company that has a platform that has some discretion, and then maybe you have some self-directed in there as well. Be thoughtful about what your advisory agreements say on that point. I think in this environment, it would be very difficult for a regulator to come in and be too critical about that. I will add 2 caveats because every lawyer does that, right? The SEC has said that there are some conflicts that cannot be disclosed away. They just can't be by including them in your disclosures. They're just so inherently risky or bad for the client that there is some obligation for the institution to not do them. Now, I've seen people stand up and challenge the SEC in the face of those, and they'd say, well, maybe that part of the business is not for you. maybe you're a prudential and conservative investor and you're not going to play in those parts of the market. And you certainly don't have an obligation to do it if it's not in the best of your client. And so maybe, a particular clients in a particular asset are not for you. But they've never put any other meat on the bones than that. I mean, I think it's a catch-all statement to say that there are some things for which disclosure is inadequate. Doesn't matter what it is. They obviously will not provide an exhaustive list of what those things are. They'll just say, you know what, you see it.
That's an interesting comment because I have my CFA. And if you look at their code of ethics, if a client tells you that they want to do something, you're pretty much obligated to do it, right? Within some sort of reason, I guess. But
What I guess I'm saying is I have seen at tension investment advisory agreements that say something different than that.
Yep.
And so you'd either want to square that or make reference to that. And just no one understands what your agreement says are the rules of the road.
That was going to say, my experience in that role has been that was not enough to have them just direct you, but to also amend the agreement and have the agreement updated in front of the client. If to protect yourself, not necessarily from the regulator though, from when it goes bad, the outside lawyers that are looking to profit.
A lot of agreements were updated back in like the mid 2010s, and the reason why they were
crypto in them.
Well,
That's what we're thinking.
No, actually not crypto, but to what Mark is saying, which is really important, it wasn't so much for crypto purposes, but it was for elder abuse. It's like a lot of investment advisors were having to deal with, they'd get this strange phone call from John Smith, and they had been dealing with Jane Doe, who was a retired teacher in her 80s, for years and years and years. And all of a sudden, this 20-something-year-old kid, John Smith, was calling up and saying, oh, direct $10,000 to the local Rolls-Royce place. And a lot of investment advisory agreements were then updated to have this type of protection, to allow for this type of protection that Mark is saying. And I think it flows very nicely into the digital asset space as well, too.
Well, Mark, are we still in the era of gatekeeper liability, or is that, your experience, is that gone? There's no longer gatekeeper liability?
So there has been
he would consider a gatekeeper.
Yes.
Yeah.
So there's been a bit of a retreat from the very austere gatekeeper liability that, around 2016 was really top of mind for anybody who served as a fiduciary, chief compliance officer, where, they were very rightly concerned about taking the bullet for whatever the institution has done. That doesn't necessarily inoculate one against a view from a regulator. Everybody at this table has dealt with regulators who have been presented with a very robust disclosure to investors. Not only that, it's in the disclosure, but sign here, sign here, sign here. Oh no, we're never going to create a whole separate thing. So that everybody knows that it's been reviewed and signed by, and then they still said, no, this is per se unsuitable, right? And so you really have to talk about these things on a risk continuum, and you can only use the tools that are available to us. I think that this particular administration, if I'm guessing, but what is happening when the chairman was asked this question this week, all he really said was that we want broker-dealer investment advisors to 401ks to exercise their fiduciary duty to look out for these retail investors.
Good luck. Good luck with that.
And so, which is an answer, not answer, unless it is coupled by any easing, any rulemaking that is going to provide any more cover. Sounds like for now, he's putting the onus on the fiduciary, and so you just have to be more thoughtful and document your rationale for the things that you are doing. But if I had a crystal ball, and I'm guessing here, and I don't have to provide the disclaimers anymore, the thoughts and opinions are my own and not necessarily represent. I think that this is going to be coupled by some rulemaking. There'll be a pretty significant push for as much as lots in the industry were complaining that there was an avalanche of rulemaking that was coming up in the last administration, and there was. You could hardly keep up. I think that this will be one area in which there will be some contours around rulemaking, mostly because it will accommodate this push to open access to retail investors of these other products. Because for almost my entire career, there just were different rules for retirement accounts.
Yeah.
Right. In order to protect, or if there's an alt component, it's a very small sliver, so that the risk to the overall portfolio, right, is minimal, and you minimize the risk in that way. I don't know if they're just take the lid off of that, or if they're going to provide special exemptions for the person who would previously take the bullet. And so I guess we'll see.
Yeah, I was going to suggest, especially as the retirement accounts, there's maybe an administrative-driven push or an industry-driven push for that to be the new frontier of new capital into these products. Rulemaking will help because of what could be or should be the skittishness of any fiduciary of countenancing that, if not recommending that themselves. So maybe rulemaking will give the cover that you all or the investment advisor may need in order to follow through with this. Just because it's available doesn't mean it's a good idea. But I have a feeling that from the top down, there's going to be something that fills that gap from what's available to what's actually going to be happening or what's recommended.
So Mary had a question over here.
Does it help at all? I've only done this twice, but does it help at all if you have the client sign the investment parameter page? Like I literally I come from the institutional world, so I document the investment parameters and I date them. And for certain clients that I think might be skitsy, at some kind of risk, I have them sign them. Does that offer me any protection, or is that just a ruse?
It doesn't hurt.
Yeah, it does offer you some protection. If it's not documented, it didn't happen. And if it's not acknowledged or sent or signed by the investor, it didn't happen either. So you going through that process is an attestation by you and the customer that this conversation happened and it went like this and the customer wants to proceed. So it does help.
This is actually just the guidelines, right? But you're right. I also have that in the notes, but then on my actual guidelines, which is what drives everything I do for every client, I have an investment parameter page, and only for a couple, like including the one that came to me when she was 89, I made her sign it because I want to take on added risk.
It helps, but think about who's signing it. An 89-year-old who may not have the knowledge or proficiency or even the faculties for that to mean anything. So it's a give and take. Having it helps. Whether it stands up and has standalone value really depends on the facts and circumstances and whatever backup you have and whatever story that 89-year-old's lawyer is telling that differs from what's on the page.
I'll say it opposite. I don't like my chances if we don't have that.
Yeah.
But I like
yeah.
But I like having it. It gives me something.
Because that means it happened.
Right.
If it's not written down, it didn't happen.
Right. So this has been a very robust discussion. We've touched now on some client interaction points. So Rich, what are you seeing in private litigation, customer-client disputes? What are the issues there? And maybe we'll do this in sort of a rapid fire fashion. We only have about 10 minutes left.
Sure. The scoping out of the engagement is really important. What is the investment advisor to do? What are the services he or she or it are providing? One issue that we've run up against, and maybe you all have dealt with this, is the tax ramifications of any piece of investment advice. Oftentimes we're not tax professionals. Go seek your tax professional's advice. Go to your CPA. We are not your CPA. But if your conversation touches on these issues, you're all of a sudden wading into those matters. So if you're going to make a representation that something is tax advantage, tax preferred, or even helping them exercise shares and pay down what's owed for restricted stock units or something to help them navigate holdings in their own company into the broader investment space. Anytime you're doing anything like that touches on a taxable issue, make sure your client knows that you're not providing tax advice, because what we've seen is anytime there's fallout, instead of going to their accountant who may not have the deepest pockets, they're going to go to the investment advisor for doing anything that had tax ramifications. And if you don't disclaim it well enough or specific enough, that's going to blow back on the investment advisor. So that's something I've seen litigated a couple of times, 2 or 3 times now, despite the language of we're not your accountant. As soon as you wade into that issue without having the accountant on the phone, it may be a matter of the investment advisor's liability, or at least a claim that it is. So that's something I've seen. And scoping out your services, what's not covered, and making it crystal clear is a helpful exercise.
Are you recommending that be done in writing?
Yes. in writing and in practice, get them, the customer, to say what the accountant said about this transaction and note that. So now all of a sudden you have a learned professional discharging their duties, which are different from the advisor's duties, which are probably, if your agreements look like some others, disclaiming any provision of those tax services.
Can you say something like, this is what I believe, but you need to verify this with your tax account?
If you believe it, you better have a basis for believing it.
You have a basis,
And then if you are wrong,
but you need to verify before relying on this information with your tax advisor.
yes, and I would be really clear that you won't proceed until and unless they went to their tax advisor to double check or, for the first instance, do the
A
analysis.
lot of times it's off advice. It's, I'm doing this, what's the tax effect? And you say, well, I think it's this, but really you need to get very specific and go to your tax advisor and verify this. Because I am not a tax expert.
This is waiting in the exact fact. I dealt with 2 of these issues in the last 2 years. This is very similar fact patterns, and the advisor ended up being accused of giving bad advice. So I know this is a trap for the unwary, but that's why I wouldn't proceed unless and until you have a notation that they checked with their tax advisor, and now we're proceeding. It also takes a certain kind of client to push this theory, but if things do go wrong and the tax advice or your belief turns out to be wrong, they may look for recompense from somebody, either you or the accountant, and if it's you, then it's your turn.
And if they don't have an accountant?
Then it's even more based on the advice that you gave. It's subject to them seeking advice from ChatGPT.
So the first iteration of this was an inclusion, so all the legal mishmash gets in, right? Was a disclosure that you should seek independent, legal, accountant, tax advice on the suitability of this investment, or advisability of this investment for you, right? Then people were sued off of that, right? And so then attorneys added a second section that says that your advisor may detrimentally rely on your representation that you have sought all of this advice necessary to make an informed decision about the fitness for this investment for you. And then someone sued off of that, right? And so this next step, again, is not an identification, a bulletproof against liability, but is another thing that is very helpful to people who have to answer these questions when someone, despite having signed all those things, is still intent on litigating. We always say we can't stop somebody from suing you, but we can advise you on the best tools that you can utilize if someone does.
Very good. So very quickly, I'll kick it to you, Marc. Anything in the private litigation sphere that's being driven by cybersecurity issues, data breaches, is that a mushroom event that's happening, or is it still just slowly growing?
It is, and we talked about how this is a growing area, and it's probably for good reason that we keep this at the front. Cyber is a issue right now that it's administration agnostic. Everybody's thinking about it, and the risks attendant to those are not the province of I think regulatory ebbs and flows. So cyber is included as a hot topic in almost 50% of all investment advisors who were recently surveyed. And then you add in another 10% where they talk about vendor due diligence, which is almost 100% cyber, right? So I would say that these issues are probably almost 50% of what folks that are doing what you do are thinking about today. I guess if there's any silver lining, it's that the Supreme Court, since the TransUnion decision in Ramirez, has said that you have to prove actual harm if one is claiming that there has been a breach. This has been holding for now, but it's also created a rush to the courthouse of anyone who has actual harm. So as recently as last month, the Fourth Circuit Court of Appeals issued a decision that basically dismissed all of the claims. So there's been a years-long issue of people filing as John Doe, as being a victim where there's been some intrusion.
Mm-hmm.
The Fourth Circuit said you have to have actual harm. You have to prove some actual harm. And so that held up. But there were two people who could demonstrate that their personally identifiable information was existing on the dark web, and that's the place it could have come from, ostensibly. And so the dismissal was largely successful, except for those two people. So this is something that we monitor, and it crosses lots of sectors. It just doesn't apply to financial services. It's just that these last two cases were financial services and those that are selling insurance products. As recently as last week, there was a Florida district that also reiterated that you must demonstrate a concrete and particularized injury in order to have Article 3 standing in federal court. And so they threw it out. But this means that compliance, the note I wanted to make is it means that compliance must have robust cyber policy and procedures. And it's crucial that you have cyber incident response methods that can demonstrate whether the intrusion resulted in any harm. Otherwise, you're setting yourself up. You're not giving your counsel any ability to push back and defend.
Very good. So we'll close this discussion by sort of looking ahead as best we can. The old crystal ball, as Marc likes to say. My first question is for you, Marc. Do you anticipate AI becoming more prevalent of an issue in investment advice, marketing, and on the flip side, how it's used either in compliance for surveillance purposes, within firms or by the regulators to identify anomalies and identify deficiencies that they're then going to pursue in enforcement?
Yes and yes. If I was sitting in that seat still, it'd probably be the thing that I was thinking most about. It's all the ways that my institution was using artificial intelligence. Anybody in financial services knows that financial services has been using what we're calling now artificial intelligence for many years in various different ways. But now everybody has access to it. So I would be thinking throughout the institution about all the ways that it is being used. Our portfolio managers using it to write things that are describing products and services in ways that they shouldn't. Are we using it to come up with policies when we know, though we don't know why, that AI hallucinates, right? And so I'd have to have a cyber policy around that. So that's internally. Regulators actually use it too, right? Mostly they call them advanced surveillance features. But we know that nothing goes out from the regulator after they get the results back, and they still have a person that actually checks those things before they go out in any type of enforcement inquiry. So you're going to have to know and understand how it's being used in your institution. And as much as I'm afraid of all the ways that it hallucinates, I think adoption is necessary.
So a headline again, yes and yes. Rich, one piece of advice for the RIAs the next 12 months to either avoid getting in the crosshairs or to navigate a sticky situation that is likely to involve potential downside enforcement risk?
Yeah, I think we talked about it as the advisor space and as customers become more interested in alternatives, digital assets, and some of these private placement or private assets. Documentation of the product due diligence on the front end, especially with respect to custody. If it's a digital asset, understanding the technology at play and documenting it at the company level, at the firm-wide level, and then at the individual RIA level, that everyone understands the technology underlying the digital asset, whatever AI tool is being used internally, and able to explain that in layman's terms and also document that internally. I think that's going to be a prerequisite if anyone is going to be recommending or putting any customers into these products. That's at the base level. And also, again, going back to the marketing rule and all that, if you're using AI and you're touting your use of AI in your processes and procedures, make sure you substantiate it, make sure it's documented internally, what's being done, what the parameters are, and the coaching around it, and making sure that what you say you're doing actually matches what you are doing and what is documented that you're doing. And again, back to these alts and these other investments, documenting this kind of decision tree matrix and the thought process of making it a part of a portfolio, model portfolio, and then taking that model portfolio and applying it to the individual customer at the end and documenting that and the conversation you had or should have had or the disclosures will be necessary if and when there's a blow up, if and when there's a downturn. If you heard me say it twice, you heard me say it 100 times. If you didn't document it, it didn't happen. So having this at a firm level and in your CRM at a customer level, with a date and a time and a who, what, where, and when was involved with this is necessary if you're going to hand it off to defense counsel in a God forbid scenario.
So
there's a lot of platforms now that will integrate with CRMs that will transcribe, record, whatever conversations, right? Are those acceptable in terms of being able to document conversations? Those the handwritten notes or typed notes?
And those are better. I mean, as a lawyer, that would make me cringe, right? Having any conversation recorded, me as the lawyer. But you all, better yet, because now you can hear it if it's recorded or transcribed. You could have the words of the customer written down and not just their initials or their signatures.
How would you feel if it was summarized by AI? So it wasn't recorded, so you're not recording someone illegally, depending upon state law. It's not transcribed because it wasn't recorded, but it's summarized.
Notes help. Having an explanation as to why this process or this tool works for this, and having that note and file and that someone investigated whether this is a good tool for this purpose would help. But more information, more record keeping, the better. But make sure you keep it. Don't just throw out the bad conversations and keep the good ones. Keep them all.
Save them all.
Save them all. The good, bad, or the ugly. But I'm for it because more documents in the file is demonstration that you're performing your fiduciary duty. And again, better yet, informed consent or informed understanding by the customer is really helpful on the back end when you hand it off to your lawyers.
Perfect.
Go ahead.
I'm just adding, if you are using those technologies to do your note taking and there is counsel on the phone, make sure you ask them, this is being recorded.
Yes.
And it's okay if we use this, for this meeting with this device, and give them the opportunity to weigh in. Because if it's advice, then it's advice, and we could talk about the protections and if the reasons that it might be violating. You want to make sure that counsel isn't inadvertently blowing that just because he doesn't know.
Yeah. I actually have a different take on the note taking because there's such a thing in our society now about AI hallucinating a great deal. If all of a sudden the notes come back as being very positive for one side or the other, that's going to be called into question. On that note, I want to thank Brian and Rich and Mark again for doing this yeoman's job. And please, 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 if you have any questions, reach out. Mark's comment about people, suing, and Rich, talking about it never happened and everything reminds me of the story of Alex Rodriguez's divorce lawyer. He's coming out with a new book too right now. And he talks about his divorce and everything. And there was a great story when his wife was divorcing him. She had all these salacious allegations, put them in a complaint, and it was filed. And Alex Rodriguez had one of the best divorce lawyers in Florida. And the press caught him on the courthouse steps one time, like this very wise, like right out of central casting lawyer. And they're screaming, asking questions. What does Alex say about this? What does he say about this? What does he say about that? And some of you probably remember some of the allegations. And he waited for a pause in the screaming from the press. And he just looked at the press and he said, in a very low tone, he goes, anybody can pay a filing fee, and just walked away. He stunned the entire press. And that's exactly what will happen. Sadly, no matter how much you document, no matter how much you do, it may not stop the plaintiff's lawyer. Sorry to say that, everybody. Now, we're going to move into our networking event. We want everybody to get an opportunity to meet each other and everything. We're going to reconvene at 2:30 for our last session, okay? Which will be on demystifying the merger, aggregation, and sale process.